The judges of the United States Court of Appeals for the Fourth Circuit. Oyez, oyez, oyez. All persons having any manner or form of business before the Honorable, the United States Court of Appeals for the Fourth Circuit are admonished to draw nigh and give their attention, for the court is now sitting. God save the United States and this honorable court.
You may be seated. I want to welcome everyone to the Fourth Circuit Court of Appeals this morning. We have three interesting cases and lots of good lawyers. And we're looking forward to the arguments. In the first case, United States versus Edwin Brown, Mr. Rivez, good to have you with us. You can come to the podium and explain to us what you want to say.
Good morning, Your Honors, and may it please the Court. Joshua Rivez for Appellant Edwin Brown. Mr. Brown's counsel told him there was no difference between two ways of entering a guilty plea. Counsel was egregiously wrong, and after entering an open plea, Mr. Brown received a sentence that was 7.5 years higher than had he accepted the government's plea deal. In this federal habeas proceeding, the government concedes that Brown's counsel performed efficiently, but contests that Brown was prejudiced by that performance. But Brown was prejudiced because there is at least a reasonable probability that, but for his counsel's bad advice, Brown would have taken the 10-year plea deal. The reasonable probability inquiry is unusually straightforward here. We know that Mr. Brown was open to pleading guilty because he pleaded guilty the same week he rejected the government's plea offer. And it is self-evident that there is a significant difference between a 10-year statutory maximum and a 90-year one. So any defendant desiring to plead guilty would have accepted the government's plea deal. That is all clear from the cold record, which is why the district court erred in demanding that Brown submit additional contemporaneous evidence to prove his case. And, again, contrary to the district court, there is no evidence weighing on the other side, not the appeal waiver consideration.
Aren't there factual findings that you have to contend with? I know you say any defendant would have taken the deal, but the district court made some factual findings about what mattered to this particular defendant, and we have a pretty high standard of review for that, don't we?
Yeah, so I have two responses to that. First, I don't think they are factual findings. I think they're assessments of how the defendant would have acted counterfactually. Strickland makes clear that the prejudice inquiry is a mixed question of law and fact that this court reviews de novo.
So you think it's not a factual finding that he would not have waived his right to appeal, that mattered to him more than...
I don't think that's a factual finding, but even if it is a factual finding... And
How is that not a factual finding?
Because it's an assessment of how he would have behaved in a counterfactual world that was never...
Is that not a fact? How is that the law?
I don't think it's a fact. It's a question about how he would have behaved in a world that never happened.
Do you have a case that stands for that?
You know, I think this court in Merzbacher and Martin always reviews these counterfactual questions through de novo inquiry. The court has never, assessed this exact question, but I don't think you need to assess...
Wasn't there testimony, and didn't the magistrate have to weigh some credibility?
There was testimony. I don't think the magistrate made an explicit credibility finding in this case. I don't think that you can infer a credibility finding from the way the decision was written. But I guess my second answer is that you don't need to worry about any of this, because to the extent there was a finding, it was a finding infected by a legal error because it rested on Brown's conversation with Wentz after Wentz provided the bad advice. I think the law is very clear.
And what exactly is that are you talking about a Rule 11 colloquy?
No, I'm talking about, Wentz testified. My client cared about the appeal waiver, but that conversation occurred after Attorney Wentz told Mr. Brown that there was no difference between
I thought both attorneys said that. The attorney who wasn't deficient said it.
Did you tell him?
And the attorney who was deficient said it.
I'm sorry.
Yes, so I think the conversation with Wentz is clearly out because it came after the bad advice. I think the conversation with Harper has no probative value. The district court didn't rely on it. The magistrate judge didn't rely on it, and for good reason.
I thought the magistrate judge, in fact, said that he did credit both of the attorneys' testimony. He found them credible.
Yes,
that's the word he used.
I certainly agree the attorneys are credible. I'm not meaning to contest their credibility. At the time my client was working with Mr. Harper, he was not open to accepting a 10-year plea deal. We know that by the decisive time, he was open to accepting a 10-year plea deal because he accepted he pleaded guilty in a way that he thought carried with it a 10-year statutory maximum. So between his work with Harper and his work with Wentz, his thinking about this case fundamentally
And
changed.
there was a letter where your client said something about the appeal waiver, that how he didn't want to give that up.
So he didn't say he didn't want to give it up. He alleged that the government was retaliating against him because he didn't give up the appeal waiver. I mean, the letter is not, I admit, a model of clarity, but nowhere in that letter does he say, I insisted on an appeal waiver, excuse me. And I think there's a good reason for that.
It just strikes me that what we're talking about now are facts, and you have your perspective on the facts, but we have a standard of review for how we review those. And I realize you have arguments for why we should look at the facts your way, but it doesn't seem correct to say that there's no factual impediment to ruling in your favor.
Well, I mean, the ultimate standard of review is the reasonable probability question. The court reviews reasonable probability de novo. To the extent that you think that the court said, as a factual matter, I think he cared more about his appeal waiver than the 10-year sentence. Again, a question that was never put to him due to counsel's deficient performance. I do think that finding rests on the legal mistake.
How many years was he facing?
He was facing 90 years under the open plea.
90 years on the plea deal.
90
The
years.
plea, not the plea deal.
Correct.
The plea. He was facing 10 years on the plea deal.
Right, and that's the...
With 90 years, did anyone ever say you were facing 90 years?
His attorney never said that.
His attorney never said that. Did the judge ever say that?
The judge did say that during the plea colloquy after my client made the decisive decision to reject the
Did he
deal.
say 90 years? Or
He
did he say
said-
20 years on each count?
He said 20 years on each count, and then 10 years on count 5.
Did anyone ever say 90 years?
I do not believe that
I mean,
anywhere...
you said it early, and I was going to ask somebody if anybody ever said 90 years. You said that early, but they could be end to end on the maximum punishment.
Yes, I do not believe that anyone ever said the words 90 years to my client.
Okay, but there's no question that each of the drug offenses was a 20-year offense,
Correct,
and they're separate crimes.
correct.
And the plea offer was plead guilty to count 5, the gun charge, which has 10 years, and we'll dismiss the other 4 counts, the drug counts,
Correct,
which meant a maximum of 10 years.
which meant a maximum of 10 years. And my client
But
thought...
the affidavit or the declaration of the lawyer talks in terms of the sentencing guidelines. Of the guidelines, what the guidelines are going to be, or whether they may change. But it doesn't say much about the permissible punishments.
So I think that was...
What's going to happen to those?
Correct. I think that was Attorney Wentz's error. He advised my client on the guidelines range, but he did not correctly advise my client on the statutory maximums. He said there would be no difference between the statutory maximum under the open plea.
He doesn't say anything. He never told him that you're facing 90 years on the charges in the indictment.
Correct. My client thought that whichever choice he made, he would face a maximum of 10 years. I think that's common ground between the parties.
He said he would face the maximum of 10 years? He said the guidelines would have a maximum of 10 years. What did he say?
I believe he said there was no difference in the sentencing exposure between the 2 ways of entering the plea.
This is what the lawyer told him.
This is what the lawyer
judge
told
him you could get 20 years on each count,
Correct.
okay?
So the lawyer did not give my client the guidance he needed, which was that he was facing a choice between a 10-year maximum on the one hand and a 90-year maximum on the other hand. And, going back to Judge Rushing, your questions, anything my client said about the appeal waiver at that point was infected by that misadvice.
Well, what about once he was actually sentenced to more than 10 years, and he was given an opportunity to speak to the court and had nothing to say? The magistrate found that some evidence, it's not dispositive. And the same with when he flagged problems for his appellate attorney. He flagged a problem with his plea counsel, but didn't mention this. Again, not dispositive, but the magistrate and the district court found that to be some evidence of what he would have done contemporaneously, but once he found out that the guidelines weren't the only controlling factor.
Yeah, so he didn't say anything at the sentencing. I think it would be a lot to ask a defendant to kind of interrupt the judge and say, Judge, I was told
You
that.
don't have to. At a sentencing, the district court actually gives the defendant an opportunity to allocute.
Right. And I think the inference that one could draw from that is that his lawyer correctly advised him, but that's not this case. We know that his attorney incorrectly advised him. His attorney said so in an affidavit. So, there's no question that my client went into this thinking that he had a 10-year exposure and came out of it with a more than 10-year sentence. Now, why he didn't kind of object at the time is a question that I don't know the answer to, but I don't think you can take much from that, nor from his decision not to appeal.
Well, why can't I take much from that? The magistrate judge and the district court found it persuasive. They made factual findings, and I'm reviewing that. So give me your best argument for why that was a legal error or why it was clearly erroneous, why it can't factor in to the analysis.
So the question of prejudice, what would he have done in the counterfactual world in which he had been correctly advised, I think does not really have anything to do with whether he would have objected to his sentence at the sentencing hearing.
Well, no, I mean, the point is you look for, it's easy to say later, I would have done something different. So courts try to look at the time and see what can we find out about what the defendant would have done. And when they see, well, he was sentenced to a lot more than what he claims he thought he was exposed to, and he claims that the length of the sentence is the overriding factor. But when this happened, there was no expression of surprise or, hey, my attorney told me I couldn't get this much. I'm confused. Again, not dispositive, but courts are allowed to look at these questions, at these facts.
So I think he was confused. I mean, he testified that he didn't understand what happened to him until he got to prison and spoke to someone there. But I think what makes this case easy is that the counterfactuals are just more straightforward than they are usually. We know he was open to pleading because he pleaded. This is not the kind of case, there are difficult cases where someone goes to trial and then says, well, I don't like what happened at trial. I want to take that back. I want to plead. I mean, he pleads a day or two after he turns down the plea deal. The only thing he cares about, the record is very clear, was his ultimate sentencing exposure. There are difficult cases where...
Is the record clear? I mean, I'm not trying to argue with you here, but you can't say the record's clear, that's the only thing he cared about. The magistrate in the district court said he cared about his appellate waiver. He cared about trying to, even when it came to sentencing exposure, he thought he could make some traction with the judge by pleading to everything versus pleading to just one count.
No, I completely agree, and I'm not meaning to contest that. I'm just trying to say that it's sentencing exposure either way, right? The goal of the appellate waiver, supposing that he, really would have cared about that had he been properly advised, was to reduce the years of his sentence. When you plead guilty, however you plead guilty, whether you plead open or you plead with a deal, you're not appealing your guilt or innocence. You're appealing the years of your sentence. You're appealing procedural reasonableness, substantive reasonableness. Judge Gregory, you were on the panel that adjudicated Mr. Brown's direct appeal. It was just a kind of guidelines, reasonableness appeal. So, his whole strategy was reducing the number of years he wanted to spend in prison. Now, I agree that kind of there are different ways of going about that and that that's what this record is about, but this is not the kind of case where someone cares on the one hand about immigration consequences, on the other hand about years, and you kind of have to weigh apples and oranges. This is a case where my client's objective was to spend fewer years in prison, and I just think it's hard to say that there's not a reasonable probability that had he been told 10-year maximum, 90-year maximum, he would have made the choice to face the 10-year maximum. I mean, I think in that respect, this case is a lot like the Baker case, the Third Circuit case that we flagged in the 28J letter, where the court there said, there are credibility findings below. I think there were clearer credibility findings in that case than there are in this one, but ultimately it doesn't matter because the question is reasonable probability. The disparity is so great that we believe that any defendant in his shoes, had he been properly advised, would have taken the deal. I think that is clearly right here. I think it would have been irrational for someone to face 80 additional years of a statutory maximum in order to preserve their right to appeal the reasonableness of the sentence. And I think at the very least, given that reasonable probability is not a preponderance of the evidence, it's
But
something...
Judge Rushing is exactly right. There wasn't a complaint about it at the time. I mean, he stood mute when the judge gave him 17 and a half years, and his lawyer did.
Yes, both he and his lawyer did not object to the 17.5-year sentence.
And the government, though, admits that the lawyer conduct was deficient, constitutionally deficient. The question is prejudice. The only issue we got is prejudice.
Correct, and I think that's also...
And does anything in this record indicate he was ever told, you face 90 years in the penitentiary?
No, I do not believe he was ever told that. His
Is that
attorney...
what- no. Does the record indicate that he was ever told 90, you qualified it. Can you tell me absolutely he was never advised on this record that he faced 90 years?
He was never advised on this record that he faced 90 years. And that's what was deficient. I mean, deficiency is conceded here. That's what makes this case different than some of the other cases where, an attorney properly advised him. And again, I just
But
think...
there was no, and this is a question I don't know the answer to, there was no testimony from the first attorney, the attorney who was not deficient, that he advised him of the maximum exposure?
So no, because my client never talked to Mr. Harper about whether he would plead open. Mr. Harper brought my client a 10-year plea deal, basically the same plea deal that my client ended up turning down. And my client said, I don't want to face 10 years in prison. Please resign as my lawyer. Now, obviously, in that form...
But he never went through, when the judge says 20, 20, 20, that means you add those up.
I do not believe that they got there. I don't think that there's testimony that they got there because my client, when he was working with Mr. Harper, was just not willing to plead to, I think, the kind of deal that was realistic in his circumstances. I see that I'm out of time.
But the 20, he did tell him 20 4 times. You can get 20 on each count, right?
The judge did.
The judge did.
Yes.
And his lawyer had told him 10 was the max.
Correct, and he conferred with his lawyer.
Why didn't that flag something?
I think when your lawyer tells...
20 is twice 10.
Right. So I think it did flag something.
And then he got 17 and a half.
Correct. So I think it did flag something because that's the point in the sentencing trend, in the plea hearing.
But the 20 was, you say incorrect, it was really 90.
It was really 90 because the sentences could run consecutively. And that's the point of the plea hearing where my client turns to his lawyer and says, can I talk to you? That's on JA 52. And obviously the conversation with the lawyer
But
is
we aren't here on a direct appeal. We're here on a 2255.
Right. The only question, as you said,
Right.
Judge King, is prejudice.
So on the Sixth Amendment claim involving the lawyer.
Correct.
And the simplest part of this criminal defense work should be dealing with pleas, I would think.
And dealing with statutory maximums, which are written down in the statute.
I've been kicking around it a long time, and I thought that part was the easy part.
I definitely agree that the attorney performed very deficiently here, and that's, common ground between the parties.
All right, you've saved some time. Let's see
Thank you.
what the government want to tell us about this. Mr. Silverman, it's good to have you with us.
Thank you, Your Honor. Judge King, I'd like to pick up right where you left off. If you turn to page 52 through 53 of the joint appendix, you'll see where Judge Dever, who has never been accused of error and did nothing wrong in the Rule 11 hearing, says repeatedly, on each count you can be sentenced to 20 years. Then again on pages 55 and 56.
Did he say consecutively?
He says on each count.
Did he say consecutively?
He does not use the word consecutively.
Did he
or-
say you could get 90 years?
No, he says 20 on each count, and
Or
then
you could get 40, or you could get 60, or you could get 80?
no, he says 20 on each count, and then he says again that I can sentence you up to the statutory maximum.
But we're not, but the question, we're really also talking about directly the lawyer here. And what did he say to him? His own lawyer.
On page 516 of the joint appendix, his first attorney says he explained the statutory maximums, which would have been 0 to 20 on the drug charges and 0 to 10 on the firearm charges. Below, they never contested this issue of how much did he know the 90 years versus the 10 years.
He said, he talked in terms of the guidelines in his declaration. You were talking about that, or you talking about something else?
No, we're talking about Mr. Harper, who gave him proper advice and told him exactly what the sentencing was and who has never been accused of any error.
I'm talking about Wentz.
Wentz's admission.
I thought Wentz was the one that that was the, maybe I'm,
No, Wentz was the one.
maybe I'm focused on the wrong lawyer. I thought the ineffective counsel was, he was represented by Mr. Wentz.
He is talking about Mr. Wentz as the ineffective counsel, but the government's point here is that he had some knowledge that he was facing 90 years and that there was evidence in the record. In addition, unlike in other
Yeah,
cases,
you're saying there was evidence from Mr. Harper?
from Harper and from the
That
judge.
was the prior lawyer
Correct,
who was out of the case.
correct. And
But Harper was replaced by Wentz,
that's correct.
and Wentz told him 10 years.
No, Your Honor. What Wentz has admitted to doing wrong was not clarifying that the court could go above 10 years. He doesn't say that he said that the maximum was 10 years. That was not a fact found below.
He didn't tell him what the statutory maximum.
No, but the
He
court
said,
did.
he said he didn't focus on the statutory maximums, he focused on the guideline.
That's correct, and that's the error. And the question is, is there a reasonable probability that he would have done something different?
So Wentz didn't tell him 90 years.
No, that was the error. And but they cannot show prejudice on this record because
You agree that he could have gotten 90 years? The government does, right?
in theory he could have gotten 90 years, but there's no point that there's no case they can point to where a person in this position would have actually gotten 90 years. He was looking at
We're talking about the statutory maximum that's embodied in the indictment for 5 counts that the petitioner pleaded guilty to. When he pleaded guilty to those 5 counts, he could have gotten 90 years in the federal penitentiary.
correct, Your Honor, but
In the aggregate, they could sentence him end to end. I remember we had an old judge up here in West Virginia, and he used to explain it to these defendants, these consecutive sentences, by describing railroad cars. And he said, these railroad cars are in a row. And there's 10 years in this one, and 20 years in this one, and 5 years in this one. And you have to do one before you get to the next one, and the next one, and the next one. They're consecutive. He explained what consecutive meant and gave him examples. So here, the consecutive nature of these independent charges, 5 independent charges, aggregated 90 years.
that's correct, Your Honor.
Okay.
But in this case, they cannot show reasonable probability. And that is because what they have not shown is that under Fry and Lee's framework, in which we looked at what the petitioner wanted to do at the time he entered his guilty plea, he thought the open plea was worse than the government's offer. And that's because under the open plea, he preserved an important constitutional right and thought he would get a lesser sentence. That was not advice on ineffective assistance of counsel, but under the open plea, he thought he would get a 5-year sentence, as opposed to what his attorneys had told him correctly was that he would not get less than the guidelines if he pledged to the government.
No, the attorney told him that it wouldn't matter whether you pled with an agreement or without one. Your exposure would be 10 years. That's what he said. So in other words, it's a bonus. You mean to tell me I can go without an agreement and I reserve the right to appeal, and I can only get 10, or I can take a deal and not have it, then that's a no-brainer not to take the one with no plea. That's what he was told. That's what he said.
No,
He
Mr.
didn't his lawyer say that either way, it didn't matter? Either way, the exposure was the same, whether you pled with just straight plea or with the agreement. That's not what he said?
No, his attorney said that he
I'm
didn't.
talking about, is that what,
Mr. Brown said that,
exactly.
but Mr. Brown did not testify credibly before the magistrate judge. That testimony was not credited. Wentz's testimony was that he never explicitly said that there was no more, that he could go more than 10 years. But Brown knew at the time.
Mr. Wentz's declaration says, I advised Mr. Brown that for sentencing purposes, it did not matter whether he accepted the plea agreement.
Right.
That's in paragraph 5.
And I believe when he clarifies that in his testimony, it was in reference to the guidelines. He never said he couldn't go above 10 years. That much Wentz says he didn't take. He also doesn't admit to saying to this colloquy, to the conversation between the two of them that has been important to their case. But again, the question is whether Brown would have taken the open plea or the government's offer had he been properly advised. And his calculus of this deal was that the open plea had more constitutional rights and had a lower likely sentence. Given that, they have not shown by a preponderance of the evidence that he would have taken the government's offer, which had fewer constitutional
Well,
rights.
you acknowledge that he should have been properly advised.
Yes, Your Honor.
That there was a constitutional defect
Yes,
in failure to advise him that he could have gotten 90 years. That
we would quibble about whether the.
he was entitled to know what the maximum sentence was.
Yes, he was.
The
and-
government agrees to that,
Yes, Your Honor.
and that's 90 years.
Yes, Your Honor.
Is it right or wrong?
Yes, Your Honor. Yes,
All
Your
right,
Honor.
and you agree that he had a constitutional right as a criminal defendant in a federal court to be advised of what the maximum penalty was that he faced from the charges and indictment.
Yes, and Judge Dever did.
All right,
that.
but your position is he was not prejudiced by the proposition that his lawyer didn't make sure that he understood that. There was no
Yes.
prejudice to him, no prejudice at all. It wouldn't have made any difference
That is correct.
that he got 17 and a half years in the sentence.
That is correct because we look at how he would have assessed the evidence under Lee. We look not to a rational or reasonable person, but as to this particular defendant. This particular defendant believed deeply in his appeal.
But his lawyer said, I advised him that it wouldn't make any difference. It would not matter, does not matter. You said, you told Judge Gregory they didn't say that, but it does say that here, and I've got it in front of me, the declaration. It did not matter whether he accepted the plea agreement. If he accepted the plea agreement, the maximum he could have gotten was 10 years. You have to agree with that too.
Yes, but
So he got 7.5 extra years
he was looking at
at
the
least.
Yes.
For not accepting the plea agreement.
He was looking at the time he pled guilty, he was looking at the likely time in prison. Under his calculus, that was 5 years. And he decided to take the risk. He knew it was a gamble. And the evidence, he had to present evidence that he would have accepted the government.
The gamble was 10 years. If it was a gamble, 10. Either way, you get 10. One, you get to keep your constitutional right to appeal. It makes sense that you would take the one that you guarantee. That's what he was told. You can't get around that.
He was also told by the Rule 11 hearing that he could go above 20 years. He swore that he knew that. He swore that he knew that the advice was advisory. He swore to all of that.
Oh, yeah, but with the judge, I mean, you stand there, it's your lawyer who's your friend in the court. I mean, everybody knows that. I mean, I used to do a lot of criminal defense work. I mean, you can't depend on your lawyer giving you the right advice. You're not going to say a whole lot with the judge on the bench. I mean, in other words, he said, my exposure is 10 years. I mean, so why not go with that? Keep reserving. I mean,
And the argument, and the reason he wouldn't go with that is because he thought he would get only 5 years if he did an open plea. That is his testimony below. And he wanted to keep his appeal right. There is no evidence in the record that he would have waived his appeal right.
well, 5 is under 10, so what does that make a difference? It'd be high if it makes a difference. You're saying the difference is he thought he was going to get 5.
Yes, and that he thought that this open plea was a much better option under his calculus. And in addition, he had additional constitutional rights. And they have to point to evidence in the record to show he was willing to accept a deal that pursuant to the terms the government offered.
Well, that would be a good argument if he got more than 5, but he got the 10. He said, look, I wanted 5 because that's what I thought. No, he still didn't get, based on what he was told, 10 is what's the guarantee. Now, he may have hoped for 5, but what he was told, you can't be more than 10, so he wouldn't have a poor argument to say, I want 5. But it's north of 10 is what the problem is based on what his lawyer told him, either way, with a plea agreement or without.
Under Strickland, they had to show he was willing to accept the government's terms. And under Frye, that means pursuant to the terms earlier proposed. He has no evidence in the record he was willing to waive his appeal rights. This is an argument that the magistrate and district court found persuasive, found as a matter of fact.
What does it have to do with it? There was no agreement. No, he wasn't tied to any agreement. What he's tied to, he's anchored to bad advice. That's what we're talking about in Strickland. You're saying because you go back to what the agreement was before, well, that's erased. He didn't take it.
Sorry, I didn't.
Well, go ahead, never mind.
He played straight up.
He played
That's
straight
what
up.
they used
Yes.
to call it. Is that what you still call
I usually refer to it as an open plea, Your Honor, but straight
Well,
up
open.
is a good
He
term.
pled straight up.
Yes,
He
Your Honor.
pled to the,
Yeah,
the
he's
face
straight
of the
up.
indictment.
I mean, you're knitting your brow, like I said, something out of space. I mean, he didn't take the agreement. He said, no, I'm gonna do it because, you know, it makes sense. I get to keep what I want, that is preserve the right to appeal, but my exposure is gonna be the same either way. And so it's fine. I mean, that's not inconsistent at all,
Again,
based on what he was told by counsel. And don't you think what the counsel tells you there is very important to Sixth Amendment right to effective counsel?
absolutely, and the United States conceded ineffective assistance of counsel and said we needed a credibility determination. At the hearing below, the magistrate judge did not find the testimony from Mr. Brown credible, that he would have accepted the government's offer. That Brown did not appeal that rule. Without a credibility determination under Merzbacher, again, he is not entitled to relief. And there's a good reason why they didn't find him credible. His stories contradicted the record. He, again and again, he pointed to a conversation that didn't happen. He doesn't explain some of the conversations that did happen on the record. His story was not credible to the district court. And the magistrate judge pointed out that it was also not supported by contemporaneous evidence. He needed, under Lee and Murillo, contemporaneous evidence that he was willing to waive his constitutional rights. In this case, the most important constitutional right to him was the appeal waiver. And he has no evidence in the record that he was willing to waive his appeal rights. His first attorney said it was important to him, the appeal waiver. Second attorney said it was important to him. He says on direct appeal, I want this appeal right, and the government is punishing me for asserting my rights. All that is evidence in front of the district court and magistrate judge that he would not, as a matter of fact, have waived his appeal rights.
That sounds good, but it boils down to he pled guilty under information that was wrong from his counsel. He was influenced by it.
That shows ineffectiveness, but the question then becomes, what would he have done had he known the other side of the information? And as a matter of fact, based on the information before it, the magistrate and district court found that he would have done nothing different. And they have not pointed to evidence in the record.
And what's the standard for whether he would have done different? What's the standard? Determine whether it is what? Is it absolutely so? It's
No,
not.
no, a reasonable probability.
It's probability. Don't you think it's a probability if I've been told correctly by my counsel what my exposure was, that would inform this important decision about your being locked up in prison?
Not to this defendant on these facts. And this goes to another point that we make in our brief, and that I think it's your experience as a defense attorney would talk to us, is that in order to be affected by advice, good or bad, you have to be willing to listen to your attorney. In this case, there is no evidence that Brown listened and relied on his attorney. He got good advice from Mr. Harper. He says no to Mr. Harper. He says no again, and he says you're fired. Wentz comes and offers him the same deal. He again refuses to take it. It is his own idea to do this open plea. He never listens to his attorney on that. And because he never listened to any of his attorneys, indeed, on direct appeal, as this court knows, he wasn't even willing to let the attorney.
Was there any of the bad advice was to the effect that you face 90 years? That jumps off the page at me. And you
Again, Judge Dever in the
you
rule,
haven't got past that yet.
Judge Dever in the Rule 11 hearing never uses the word 90 years.
Well, and neither did, more importantly, did either one of those lawyers. You were referring to the first lawyer too, Harper.
Harper explained
Is there any
the
evidence that the Harper or Wentz, but Wentz is the one we're looking at, he represented him at the plea. Did he ever tell him 90 years? The answer is no.
It was not a question
And
asked.
it wasn't, and the judge didn't tell him 90 years. But he pled straight up to offenses that authorized the imposition of a 90-year prison sentence.
That's correct, Your Honor. That is correct.
That's the fact.
That is a fact. There was 90
I have a
years.
factual question about the guidelines advice. I
Yeah.
know it seems the first attorney says, I advised him about the statutory maximum and the guidelines. The second attorney, who's deficient, says, I advised him about the guidelines, but omitted to talk about the max. Did that attorney advise, or did either attorney advise him about an upward departure?
Yes.
I thought I recalled that from the record, but I can't find it for sure. Was he advised that because of beating the police officers, he was subject and likely would get an upward departure?
Yes, and that's another reason why this appeal.
And that departure was above 10 years, right?
He knew it was a gamble. I believe Harper was the one who constructed this, so I would have to check the record, but my understanding would be that because Harper was the one No, I guess I don't know where he thought the upward departure would be.
Okay, we don't know where the departure would be, but he was advised a departure was likely.
He was told, and he admitted this, that he knew this was going to look really bad. He knew that he had a district court judge who was known as a strong sentencer. In his letter to the Fourth Circuit, or I guess letter to his attorney, he says, I'm aware of this judge's tendency. And the judge found that basically this is why those appeal rights were so important to him. And both the magistrate judge and district court found, as a matter of fact, that these were of the utmost importance to him. They have not challenged that finding below.
Which was the most important to him?
The appeal rights.
Pardon?
The appeal rights.
The appeal rights.
Yes.
And you referred that as a constitutional right.
Yes, Your Honor, I believe so.
Where does that come in the Constitution? I thought it was a statutory right.
I thought it was a right that
1291,
if you,
final order,
if it was a
that's in
constitutional,
this code.
if it was a constitutional issue though, that even without 1291, there would be no right to an appeal to the Supreme Court at least. That would, it may be statutory to direct, it's clearly Congress's authority to direct how appeals get conducted.
But he was interested in appeal
Yes, he was.
for some reason.
And he,
But
obviously,
But the question is whether a defendant, if the question is that a defendant is entitled to know what the permissible sentence is, was he advised here?
Your Honor,
And was there a reasonable likelihood that they didn't know he'd faced 90 years, that he was going forward with these 5 guilty pleas, which is what he made?
Your Honor, under the rule, as far as I'm aware and as far as their brief cite, the Rule 11, the requirements of a Rule 11 hearing, Judge Dever followed those. They've never pointed to any error. He says 20 years repeatedly on each count. It has never been that you need to say that 20 times 4 is 80. He then says 10 years again. So he knew at least 30 years, and there's no reason to think he would have ever gotten 30 years. So it doesn't, but there's also whether this is how he factored into his calculus.
Well, the lawyer said it wouldn't make any difference whether you get a plea deal or not. I advised Mr. Brown that for sentencing purposes, it did not matter whether he accepted the plea agreement, because the guideline range would be the same.
Yes, that is.
That's what Mr. Wentz says he told Mr. Brown.
And then, as in LeMaster and as your dissent in Murillo pointed out, there was this Rule 11 hearing. The Rule 11 hearing explained it. He swore at the Rule 11 hearing he understood that these were advice that he had gotten and that the court could go up to 20 years on each count.
Yeah, but the problem is, counsel, he never received proper advice on what it would cost to reserve the right to appeal. Granted, he was interested in that, right? The problem is he was never informed what the cost is. You tell a client, okay, that's what you really want, but let me tell you, the cost of that is 20 years, whatever, 90 years exposure. Then you can weigh it. Oh, okay, right to appeal, or I can get this. But here he was told the cost is 0 because you can get 10 going this way, 10 is the max going that way. So who? Well, then I'll throw in a right to appeal. I mean, it's just, he never had, that's what's so important about our system, right? The Sixth Amendment, and that's why, Gideon had to pencil write that petition. It used to be, you didn't have counsel at all, just kind of go in there. That's an important part of it. He never was told what the cost is. And that's the key. It's like saying, okay, well, we don't know what it is. He wasn't. That's in the record what Judge King read to you. That's what he was told. And say that the government's saying, oh, that doesn't matter at all, but the judge said something. Judges, that's a difficult situation. Your lawyer is your partner. She's the person that you stand up with, stand in the well with. They tell you that, and then you say, well, I know the judge is saying all those things, but your real exposure is 10 years.
And you're right, Your Honor, and that's why we never contested ineffectiveness. But the question then becomes prejudice as to what this defendant, on his own views of the law, would do. And the burden is on them to show it. And the only evidence they offer is the disparity. But they show no evidence that he was willing to waive his appeal rights. And we know that he viewed this very differently from how his attorneys or you and I viewed it, and wouldn't listen to his attorneys. And therefore, he thought he would get a lesser sentence by doing the open plea. there is no evidence that given the chance for that 5-year sentence, which would have still been on the table had he done the open plea, he would have taken away the risk of a higher sentence. It was his risk aversion and risk tolerance that we're looking at, and on these facts,
But his lawyer told him there wasn't any risk. It didn't make any difference.
it did make some
It
difference.
did not matter whether he accepted the plea agreement,
Oh, but he
because the
testifies that,
guideline range was the same, and he pled the whole thing, and he got 17 and a half years.
I think it's page 501 of the JA, and it's also in his deposition testimony where he says he knew it was a gamble, so he knew something could go differently if he did the open plea. He thought he would get a lesser sentence, and whether he was looking at an additional year or something, because he repeatedly says that it couldn't go higher than 10 years when the guidelines range were only one.
Who was supposed to tell him he could have gotten 90 years?
The district court, as it did, and its
The
attorney.
first person that should have told him was his own lawyer,
Correct,
and that's Mr. Wentz.
correct.
He should have told him, you can get 90 years.
Again, yes, Your Honor,
Now,
that's,
the question is whether his failure to do that is prejudicial. Because you admit that as a constitutional matter, he should have been told, you can get 90 years. You can get the maximum punishment, end to end.
yes, Your Honor.
Five-count indictment. And
Yes, Your Honor.
Each count has its own offense, and each count has its own penalty.
Yes, Your Honor.
It's not complicated.
The inquiry from Fry and Lee is
The question is whether the lawyer was ineffective constitutionally. And that means, did he not perform up to standards, and was it prejudicial?
and
And you admit he didn't perform properly,
absolutely, Your Honor.
but you say it wasn't prejudicial.
Correct, Your Honor.
And so that's where we are. And
Yes, Your Honor. I see I'm out of time. Government submits that the judgment should be affirmed, and if not, there has been no according to their argument, there is no credibility determination. Under law, without a credibility determination, you cannot be entitled to right. So the proper standard here is for a vacatur, so that the district court can reassess and apply whatever the legal standard that they argue for is. Thank you, Your Honor.
Thank you. Mr. Revit?
Just a few quick points, Your Honors. First, I think it would be helpful for me to read the next sentence of Attorney Wentz's declaration, the sentence after Judge King you read. He says, I also believe that I did not advise Mr. Brown during plea negotiations that his plea offer contained a 10-year statutory maximum sentence, while pleading guilty to all 5 counts without a plea agreement carried a 20-year statutory maximum. My client was never told, I think that sentence makes very clear, that there was a 10-year difference on the one hand and a higher than 10-year difference, a 90-year difference on the other hand. Every decision he made was in the universe of the 10 years versus the 10 years. In that universe, strategies like, preserving your right to appeal, as you and I discussed, Judge Rushing, strategies like throwing yourself at the mercy of the court, seem like strategies to reduce your sentencing exposure. But because he never knew that there was such a gamble, that there was 80 years of potential sentence on the other side, he never had the chance to weigh the considerations that he had a constitutional right to weigh.
The government seemed to say that his first attorney advised him about the statutory maximums. Do you agree with that fact?
Yeah, so I went back and looked as my friend from the government was speaking. The attorney did advise him about the 20-year statutory maximum. Again, I don't think that matters because, at the time that we're considering was the time he was working with Wentz, was the time he pleaded guilty, was the time he turned down the plea deal. He was not in a realistic place when he was working with Attorney
Well,
Harper.
why does that matter? I mean, this whole argument is premised on the idea that what your attorney says to you matters the most.
Right.
So shouldn't it matter that his first attorney told him the statutory maximum that he faced on all of these counts?
I don't think so, because I think 4 months later you have, maybe if Wentz had been silent, that would have mattered. But Wentz affirmatively said, and this is on JA 184 to 85, there's no difference. It's 10
But
years
the
either
20
way.
years is wrong.
20 years is also wrong.
The 20 years is 70 years off. You read it, while pleading guilty to all 5 counts without a plea agreement, carried a 20-year statutory maximum. That's 70 years wrong.
So I agree that is also incorrect, but, I think when your second attorney...
That's his lawyer.
Correct.
Making the declaration that he told him he could get 20 years.
Right. And when the
The
attorney...
question is whether the lawyer gave bad advice, they agree gave bad advice, was it prejudicial?
Right. And when the attorney you're working with tells you there's no difference in a statutory maximum, I don't think you should have to think.
But, right,
like,
there's no testimony and there's no evidence that he said there's no difference in the statutory maximum, right? I thought the testimony at trial was that he said, I told him the guidelines range is what matters. The guidelines would be the same. There'd be no difference in the guidelines. I failed to instruct him about the maximum,
You know, I
right?
think
And now we're not quibbling about whether there's an error. I think that's been established. Everyone has conceded that, right? The question is prejudice.
Right. And I think that the evidence is the declaration. It's where he says there was no difference. It did not matter whether you accepted the agreement.
Right,
And then he says,
because
I
the
did.
guidelines would be the same,
Right.
but not about that the maximum was
Right.
the same. And there was testimony in front of the magistrate, right, not just this declaration.
Right. But I think the testimony is consistent with the declaration, which is that he did not properly advise my client on the maximums.
Right. What do you say to the government's argument that the only arguments you've put forward are about the legal standard, so that if the court agrees with you, that the only remedy would then be to send it back to the district court to apply the correct legal standard because you have not quibbled with its findings of fact?
You know, I think that the right result in this case is just to say, setting aside all of the findings of fact, there is a reasonable probability of
I'm
prejudice.
sorry,
That
come
is,
again, setting aside all the
accepting-
findings of fact?
accepting everything the district court said as a factual matter, there is a reasonable probability of prejudice. I'm sorry, my first formulation was an awkward one. That's what the Third Circuit did in the Baker case, and I think that makes sense. You know, the
So
contemporary...
you would have us say the district court applied the wrong legal standard. You would have us apply the right legal standard to the facts ourselves and come to our own factual conclusion about what the defendant would or would not have done?
You know, I think that I'm with you until the last clause. I think that's a legal conclusion. I think prejudice is a legal conclusion. I think Strickland makes that very clear. You know, what he
But
would...
we have competing testimony. We have testimony that doesn't agree with itself. There's a bit of credibility to weigh here. How are we to apply that legal standard here, as you suggest?
I think you can do exactly what the Third Circuit did in Baker and just say, even assuming he wasn't credible, even assuming that the attorneys testified credibly, which, as we discussed earlier, we're not contesting in this action, there is a reasonable probability, not a preponderance, it does not have to be a preponderance, that but for his attorney's bad advice, he would have accepted the 10-year plea deal.
So you think even if we discounted the defendant's testimony, said these conversations with his attorney that he says didn't happen, he was not ever advised that this was the max, what really mattered to him was the appeal waiver, because that's what his attorneys are talking about, but nevertheless, there was we can find that he would have accepted this plea.
That's correct. I think you can discount everything my client
And
said.
what's the legal error?
There are two legal errors, at least. The contemporaneous evidence standard is legally incorrect, as we discussed in our brief and we discussed a little today. And relying on advice that was infected, relying on conversations with Mr. Wentz that were infected by his bad advice is a legal error. I think as Judge Tinkovich explained in the 10th Circuit decision we cite Kern, you just
But you
can't...
agree that district court can consider contemporaneous evidence?
The district court can consider contemporaneous evidence, and there is contemporaneous evidence here. I mean, the fact that he pleaded is the contemporaneous evidence, the disparity is the contemporaneous evidence. That's the way the 2nd, the 3rd, the 6th, the 10th, and the D.C. circuits all think about this issue. And I think, you know, this case falls well within the kind of rubric set by all of those cases. There is contemporaneous evidence because he pleaded. We know he was amenable to pleading. There is contemporaneous evidence because there's a disparity. That disparity makes it clear that a reasonable person, had he been correctly advised, would have accepted the plea deal. You don't have to think that's more likely than not. You just have to think there's a reasonable probability that that's so.
So it really just comes down to your second legal standard error, where you say that, I guess, the district court shouldn't have put so much weight on certain evidence because it was infected with attorney error.
No, I don't want to give up my first legal error because I think the district court...
Well, yeah, it was not a per se rule. The court didn't require contemporaneous evidence. It looked at contemporaneous evidence, which it's allowed to do, as you have just said.
I read both decisions below differently. I read them as saying that he needed contemporaneous evidence, and I read them as assessing his credibility against the lens that he needed to proffer contemporaneous evidence. But, you know, I don't think that's going to be decisive either. I think ultimately what matters is just that the cold record, setting aside everything my client said, I'm sorry, I see I'm out of time, is so clear that he was prejudiced by this bad advice. We know he was prejudiced because he ended up with a sentence that was 7.5 years higher than it possibly could have been. We therefore would ask that you vacate the judgment below and remand with instructions for the government to offer the 10-year plea deal. Thank you.
Thank you very much, Mr. Rabbit. And I want to particularly mention that I know you're court appointed, and we appreciate your your efforts in this case. We couldn't do our work without lawyers like you and those in your firm. We will come down and greet counsel and then proceed to the next case. Number 24, 1328, Berkeley County School District versus Hub International. Mr. Patillo?
Yes, Your Honor.
Good to have you with us, sir.
Good to be here, Your Honor. Excuse me. May it please the court, Mike Patillo on behalf of Appellant Hub. This appeal concerns Hub's motion to compel arbitration pursuant to the terms of the 2002 and 2003 brokerage service agreements with the Berkeley County School District. This case is directly controlled by the Supreme Court's decision in Henry Schein. Henry Schein holds that where you have a valid arbitration clause, and that arbitration clause includes a delegation provision, there is nothing more for the district court to decide. The court must order the case to arbitration for the arbitrator to resolve any remaining disputes that the parties have about the arbitrability of their dispute. And that's the case here. The district has since conceded that the 02 and 03 agreements and their arbitration clauses are valid and binding agreements. And it does not dispute that there also contains a delegation provision. And frankly, that's it. That's the end of the analysis. Under Henry Schein, the district court had no power to do anything but to order the case to arbitration for the arbitrator to address the district's arguments that its claims do not fall within the 02 and 03 agreements arbitration provisions. Now, the district complains that, if you accept Hub's position, there could be zombie delegation clauses where 100 years from now, someone might say that there's a car crash that relates to the 02 and 03 agreements, and the district court would have no power to address the arbitrability of that issue. But that's already the law. It's what the Supreme Court held in Henry Schein. Henry Schein established a bright line rule that where there's a delegation clause, the arbitrator must resolve any disputes over arbitrability. And that's true even if the judges think that the argument seems frivolous. And if courts start disregarding that bright line rule and deciding arbitrability provisions for themselves, as a district court did here, then delegation clauses would be meaningless. But the district's hypotheticals here, they miss the point anyway. As Henry Schein itself explains, we don't really need to worry about this issue because if defendants come forward and start asserting meritless or frivolous arguments for why claims should be decided in arbitration, the arbitrator has just as much power and just as much ability and is presumed to act just as fairly in analyzing that properly and saying, you know what, you're right. This doesn't fall within the arbitration provision, so we're going to send it back to court. And that's true here. We believe that the arbitrator would side with Hub and say, you know what, the district's claims do bear a significant relationship to the 02 and 03 agreements, so this should be arbitrated. But if our arguments are rejected, if the arbitrator finds, like the district court did, that he doesn't see the relationship, then the arbitrator will so find and send this case right back to court. The only issue here is who must decide whether the district's claims are arbitrable. And under Henry Schein, the answer is that the arbitrator must make that decision. And for that reason, because the district court went ahead and addressed an issue that was reserved to the arbitrators under the terms of the 02 and 03 agreements, that's it. Reversal is required in the case. The court should order, the district court should remand and order the district court to send this case to arbitration, where the arbitrator will resolve the district's arguments. It can assert its claims there, that it doesn't think that the allegations in the complaint relate back to the 02 and 03 agreements. And from our perspective, this appeal really is as simple as that.
Do the parties, is there any dispute in front of the district court about whether the AAA rules actually delegate arbitrability issues to the arbitrator?
No, there wasn't. I don't think that the district contested that at all. We argued that that was the case under a number of circuits have held that suffices, and this court's decision in Simply Wireless looked at the
JAMS rules.
JAMS rules,
The
which were.
district court noted that the JAMS rules and the AAA rules are kind of different on that, but I know they didn't bring it up here. I was just curious.
Well, whatever the district court said about it, in Simply Wireless, this court actually, when it was looking at the JAMS rules, it looked to other circuits' law on the AAA rules and said, for purposes of that, they were substantively identical. So we're going to, follow what those other circuits have done and say that incorporation of the AAA rules, suffices and is intent to arbitrate arbitrability. This court need not actually decide that here because the district doesn't contest that. It says in its brief, we're not going to fight that battle, even assuming. So this court could, assume for purposes of this decision that it does reflect an agreement to arbitrate arbitrability. But the clear weight of circuit authority is in favor of that, and it'd be very hard to reconcile a different ruling with this court's decision in Simply Wireless.
Well, this is not the issue on appeal, but your last statement might not quite be right? Don't the JAMS rules say something like the arbitrator shall decide issues of arbitrability and has the power to do so? And AAA rules, I think, just say he has the power, right? So it's.
Well, I apologize. Maybe if I got out over my skis there, because that issue's not before the court.
I've already found it, but it's might not. They're not exactly the same.
I'm happy to stand corrected then. Well, if there are no further questions for me, I'd be happy to reserve my time for rebuttal.
Very well.
Thank you very much.
Mr. Barber?
Good morning, Your Honors. It may please the court, Philip Barber for the appellee plaintiff, Berkeley County School District. The issue, of course, I think that we would agree is whether the 2002 and 2003 brokerage service agreements at issue here provide a basis for a motion to compel arbitration. There have really been two arguments that have been asserted in the briefs by appellant. The first one, which is the main one, is essentially if two parties form an agreement at some time here, say 2003, and they agree, and it has a broad arbitration delegation provision, and they agree that it terminates in 2004, have they thereby formed an agreement to arbitrate disputes arising from circumstances and facts occurring in 2006 and later? I believe that's really the issue in a nutshell. Appellant has said that this is controlled by Henry Schein. I disagree. That case involved injunctive relief carve out to an arbitration provision. The claimant there brought a money damages and injunctive relief claim, said it therefore was not within the scope of it. That was a question that should have gone to an arbitrator. That case did not concern determination of agreements. There is a Supreme Court case that does, Litton versus National Labor Board. It's directly, I believe that case controls this question because it concerns invoking an arbitration agreement after the expiration of the agreement.
But the first question, the question for a court, right, was an agreement to arbitrate formed? Was an agreement formed? And your client agrees, your client concedes that an agreement was formed, right?
In the very abstract, was there an agreement formed in 2003? Yes. But
Okay.
the question respectfully before the court is, was there an agreement formed to arbitrate claims arising in or after 2006? And the answer to that question is no.
Why can a court decide, what does the termination of agreement have to do with whether an agreement was formed?
Your Honor, the term, as is explained in Lighton, is directly on point of that, quoting from that case. An expired contract has by its own terms released all its parties from their respective contractual obligations, except obligations already fixed under the contract but as yet unsatisfied. There are no obligations to arbitrate or do anything else surviving the expiration. There is no mutual assent to be bound to the obligation to arbitrate in 2006 or later. A mutual assent to be bound, a manifestation of mutual assent to be bound, is the formation of a contract. If you do not...
So you're saying there's, the contract doesn't apply to this particular dispute?
No, Your Honor, I'm saying that the contract does not apply to disputes based on, that arise from facts or circumstances, quoting Lighton, that occurred after the termination of the agreement. It's
I
not a...
thought Henry Schein said the question of whether an agreement applies to a dispute or not is for the arbitrator if arbitrability has been delegated. The only question for the court is, was an agreement formed?
Correct. And under Lighton, there was no agreement formed to arbitrate any disputes in 2006 or later. I do not believe it would be correct to say that because some agreement at some point was formed on something that you have thereby agreed to arbitrate anything in the future. You can agree to terminate a contract.
Well, no, you've agreed to arbitrate what you agreed to arbitrate. And that maybe you didn't agree to arbitrate the merits of this, but you agreed to arbitrate whether you agreed to arbitrate the merits, right? You agreed to send to an arbitrator this question of, did we agree to arbitrate the merits? You understand what I'm saying?
I do, Your Honor, but I disagree that that's applicable here because the issue here is your agreement to arbitrate, including this broad delegation clause, terminated. And you agreed, both parties expressly agreed that it terminated on a date certain. And so now after that date certain, something happens that gives rise to a dispute. There was never an agreement formed to arbitrate
So
that.
now the question is, what's the effect of termination? What is the contract? What are the implications for the contract after it is terminated? And you think that is a question for a court, not a question of contract interpretation that's been delegated to the arbitrator?
Absolutely, Your Honor, and that's
And
what
what's the authority for that?
Lytton is directly on point discussing that, Your Honor.
Saying that when when you've delegated arbitrability to an arbitrator, the effect of contract expiration is nevertheless a question for the court?
The scope of the delegation clause is not an issue because we're dealing with formation, right? We're dealing with formation, whether it's narrow or broad.
You've agreed that you formed an agreement.
Yes, Your Honor. And under Lytton, we have a case directly on point that after the termination of that agreement, if something happens that gives rise to a dispute, you don't have an eternal obligation to arbitrate. You agreed that your obligation to arbitrate, whether it's a broad or narrow delegation clause, the whole thing, but it does not survive the termination. That is stated explicitly in Lytton. And the only exception, so to speak, to that is, well, if it actually arose under the agreement and you simply waited, which is actually the fact pattern there, you waited until after to try to get out of the arbitration to actually come to court to assert your claim, well, of course, that doesn't work. But if it arose years after you both agreed that you would no longer have a duty to arbitrate disputes, then you never formed an agreement to arbitrate disputes after that point. There's a Supreme Court case that says exactly that. Henry Schein had to do with...
I think you're stretching what exactly that and directly on point means. I mean, we're talking about delegating questions of arbitrability to the arbitrator.
Respectfully, Your Honor, that is not what this is about.
Not
This
the
is a
merits.
formation. This is about whether an agreement to arbitrate was formed. It is not about construing the scope of the
You've
agreement.
conceded that an agreement to arbitrate was formed.
Yes, Your Honor, and as I said at the outset, the issue here really before the court is if you form an agreement and that agreement includes an express termination, does it remain in effect past the express termination?
Right. What is the scope of the agreement? How do we interpret the agreement? These are all questions that are yet to be determined. And your contract says that they're determined by an arbitrator, or maybe it does. You haven't contested that it says that.
Well, Your Honor, there is no duration dispute here, which is why some of the references to National Labor Board, National Railroad, excuse me, out of the D.C. Circuit were a little odd, because that case says when you have a date certain expiration, that's when it expires. You don't have it. You can have disputes that go to arbitration about whether, if it expires based on a contingent event like a deadlock in negotiations, or whether an option in the Virginia Carolina Tools case, an option was exercised. When you have a date certain expiration, there is no dispute that the contract expired. We're not disputing, we're not interpreting anything to say that the contract expired. We're not interpreting the arbitration clause. We're simply saying the agreement was not in force to force arbitration of anything, not any particular kind, anything in 2006 or later. And the only way to get around that is to do exactly what happened in the reply brief and here in oral argument, which is to say that it is truly an eternal obligation to arbitrate, that 100 years from now, 1,000 years from now, they'll always be able to claim, even though the parties in writing agreed that that would not be the case, that agreement doesn't matter, and we're going to say that it's eternal anyway. No other contractual provision operates that way. Certainly 100 years from now, they can't ask for money, we can't demand services. It's making this arbitration provision stand alone and unique, which is directly contradicted by the Supreme Court decision, Morgan v. Sundance, that we're supposed to be treating arbitration no more or less than any other contractual provision. We're simply enforcing the agreement as written. We're not making special rules to try to force arbitration.
This question, counsel, if you have a contract and an issue comes up whether or not that contract is terminated, is that scope or formation? Question.
Your Honor, what you just described is a duration dispute, which could be delegated. If you don't know if the contract has been terminated, if it's on a contingent event.
Well, you don't know, but they're fussing over it. The parties are saying, well, I think it's terminated. Others say, I don't think it is. My question to you, is that formation or is that scope?
Your Honor, that duration dispute.
Yes.
Right.
Right?
You're arguing over whether you're construing the contract to determine.
I agree. The question is it a scope question or a formation question if the issue is whether or not the contract is terminated?
In that case, Your Honor, you have a factual dispute that you're arguing, has this contract been terminated, which would be, is it no longer in effect? Have you?
Right.
The formation question is, have you formed an agreement to arbitrate, the disputes?
Okay, which is it?
And in that fact pattern, you have a duration dispute. You have delegated to an arbitrator the dispute on whether have we formed this agreement at this time. You can do that.
So I guess
in this case, that's not.
But to answer my question, it's scope, isn't it?
If you don't know whether the agreement has terminated.
Well, you don't know it now. One part,
that-
believe me, each side knows what the answer is. It's a different answer. That's the difference is. But they're fighting over determination. That's the scope of it, isn't it? I mean, that's right.
Your Honor,
That's the scope.
the reason that's difficult is you're talking about the scope of the arbitration agreement, which in this fact pattern, I believe is
right now, I'm just talking about a contract
that
has been formed, and the issue is now whether or not it is terminated. And I'm just asking you, is that a question of scope or the formation of the contract question?
And Your Honor, the reason that's difficult to answer in those terms is when we're using the word scope, we're talking about the scope of the arbitration provision.
No, the scope would be in terms of how is time-wise, does it cover this thing? Does it cover this time period? That's scope, right?
Well, in that sense, if we say the scope of the language in the contract that has some sort of contingent, then yes, that'd be the scope of that.
Right. And aren't you arguing?
Yes.
Okay.
Yes.
Aren't you arguing here that that contract is terminated, that arbitration agreement is terminated and no longer in effect because the subsequent ones didn't apply to it? Aren't you saying that it's no effect?
No, the difference between your example and this case, conceding in that example, we're talking about the scope of the language terminating the contract, which could be on some contingent event. Here, an authority would be the National Railroad case, When you have a date certain termination, there's no argument about scope. And that's the authority for that
Well,
proposition.
maybe the argument may be frivolous on the other side, but isn't it still a scope argument?
Respectfully, Your Honor, it is not. And again, the authority for that proposition is National Railroad. When you have a date certain termination, there is no dispute on the termination date, and arbitration provisions only apply to disputes. There's no dispute. It's not a scope question to know what, to read the calendar.
Okay, thank you.
What difference does it make if this Linden case was a labor case?
Well, Your Honor, in the appellant's brief, issue was taken with that, and in a response brief in footnote 7, there was a long string cite of cases uniformly applying this in an arbitration context. In the reply brief, then there was a pivot to, well, those cases didn't have broad arbitration delegation provisions, and then a response to that is, again, we're talking about the formation of agreement to arbitrate the issues, not the breadth of the arbitration clause. We're saying that the arbitration clause, however broad it was, terminated with the agreement because the parties agreed that it did. Then moving to the, I guess would be a fallback argument about the relationship between the claims in this case and the 2002-2003 BSAs. Some issue was taken in a reply brief that arises from significant relationship. In this case, I think it's conceded that that will get you to the same position. Did it arise from things happening in 2006 or later? Was it significantly related to things happening in 2006 or later? It gets you to the same point, and the answer, of course, is no. That's partly a factual question. It's also partly just a question of the pleadings, because that's really what controls that. It's been affirmatively pleaded that everything happening in 2002-03 was not actionable. Period. That's actually pled, and then actionable things start happening in 2006. And just a very quick, the overall fact pattern here that's been uncovered through discovery and trial is that in 2002-2003, you had an agreement under these BSAs where there's charged $100,000 a year in lieu of commissions on premiums. And then at 2004, when the 2003 agreement expired, that was abandoned. And there were no agreements because it decided we'll just go to a straight commission, on the premiums, no arbitration agreements. Then the district tried to abandon that, go to somebody else. HUB said, wait a minute, you can't do that. We're due our commissions on these insurance policies. We're going to sue you in court. And they hired a lawyer, threatened that. There was a settlement agreement saying all the prior obligations are resolved by this settlement agreement. Any disputes about this settlement will be resolved in court, but you're not debarred from future business. Then the future business, started happening in 2006, and that's when we had a personnel change from Ken Coffey, had by then been replaced by Brantley Thomas, who's now still in prison, started taking bribes. And that's when the actionable conduct began. It's separated by years from these agreements, which expired on their own terms, and it's not related to them in any way other than the identity of the parties and the general subject matter of insurance, and that's it. So in conclusion, Your Honor, I would ask that the district court's, I believe, thorough order on this matter after a year of discovery and a week-long trial be affirmed. I do not believe that there is, it would be extraordinary to hold that if you agree on that you're going to terminate all your rights and obligations under an agreement, that years later, one and only one obligation is enforceable, and that's an obligation to arbitrate anything that happens, as was conceded 100 years hence, have to arbitrate it. No other right or obligation survives the termination, but that one does, even though everyone said that it would expire. And there was a note in the reply brief saying that Coinbase wasn't on point, and I do think it has some relevance here. I would assume it would at least be conceded that if a separate agreement were formed that called out that clause and said, we also terminate this clause and aren't going to arbitrate anything happening after this date. Looking at Coinbase, I believe that would have to be an enforceable agreement. But that's exactly what happened here, only it's in the BSA itself and not a separate follow-on agreement. which again follows the pattern of the cases that have come out of the Supreme Court recently, which have been to instruct courts that these provisions are meant to stand enforced like any other contractual provision, not to make special rules one way or the other. That's what Henry Schein was about, was making up a special rule. There have been cases, with the waiver arguments, for example, that there's not a special rule about that. Enforced like every other agreement. No other part of any agreement survives its agreed termination in the way that Hub says that this arbitration provision will survive until, it sounds like I'm being facetious, but it's been conceded till the end of time. Till the end of time, no matter what the parties actually agreed to, they cannot go away. The zombie word was actually used by the district court to describe that argument. That is not the law. We have a Supreme Court case that is directly on point about how do you determine whether claims asserted after the termination of an agreement are subject to the arbitration provisions of an earlier agreement. We have a case that says that, and the rule is straightforward. If it arises from fact, the exact wording is, involves facts or circumstances that arose, that's the quote, during the agreement. That is not the case here. The district court found that it's not the case here. And so there's no basis to use those agreements to force arbitration of claims from conduct occurring years later, ironically, with an intervening threat of judicial, relief from Hub about a dispute. If the court has no other questions, again, I ask that the district court's opinion be affirmed. Thank you.
Thank you very much, sir. Mr. Patella?
Thank you. I'd like to address just a few things, but I'd like to keep it brief. First of all, counsel said that there is a case that's directly on point. He was referring to Litton that says how, what the analysis is supposed to be for determining, when a dispute that's raised after an arbitration agreement expires, when does it relate back to the contract? And I agree, Litton addresses that issue and says you look back at the time, are the allegations that form the dispute, do they relate back to the time while the agreement was in effect? The problem with the district's argument is that is a question of scope. That is a question that is reserved for the arbitrators here. The arbitrator will hear every single argument that the school district wishes to make about why its claims, about why the allegations in its complaint do not, in fact, relate back to those agreements. And perhaps the arbitrator will agree with them. We believe it'll agree with Hub. But the fact is, under Henry Schein, we have a delegation provision, and that means that, according to the Supreme Court's words, courts have no power to address that issue. That doesn't mean the issue doesn't get addressed. That doesn't mean they don't get a day to present their argument. The problem is, having conceded that there are valid and enforceable arbitration agreements, that's a question that is delegated to the arbitrators here. I would also like to briefly address some of the mentions of some of the discussion of Litton, because it was said that Litton is a case that held very clearly that this is a formation question. Litton dealt extensively with what happens when arbitration agreements expire. Not once does it remotely suggest that this is an issue of contract formation that courts decide. The word formation appears nowhere in that decision. And if you actually read the decision, once the court goes from stating its general principles to applying it here, it says this is a question of arbitrability. We are turning to a question of arbitrability, which means that's a question of scope. And briefly, just one more point. Counsel also said that when there is a date certain, somehow this becomes that it would expire on a date certain, somehow that becomes a formation question. Obviously, that doesn't make sense as a matter of logic. They've agreed that there was a formed agreement based on a constructive ratification theory. When you form an agreement, it expires. That doesn't mean it was somehow never formed in the first place. And the fact that there was a date certain doesn't change the analysis, because if you look in Litton itself, Litton said the parties agreed that it would expire on a specific date, October 3rd, 1979. But that didn't end the analysis. The fact is, and counsel again said, it seems unfathomable that one provision could survive. Just this arbitration requirement could survive the expiration. Again, that is Litton. Litton says there is a presumption of post-expiration arbitrability. And the dividing line there is, you know what, and we're not saying that we have an obligation to arbitrate any and all questions, any and all disputes that might arise in the future. We don't believe that's true, and it would, we would never assert that, in some of their hypothetical examples. But Litton says that the arbitration agreement does survive the expiration, even whereas in that case, the agreement itself expired on a date certain. There's a presumption that if it relates back to that time, that dispute resolution provision survives the expiration of the agreement, and here, whether or not their claim in fact relates to the arbitration provision that survived is a question of scope that's reserved for the arbitrators here. So if there are no more questions from me, we would respectfully request that the court reverse and remand to the district court with instructions to send this case to the arbitrator, where the arbitrator may resolve any disputes about the arbitrability of the district's claims. Thank you.
Thank you very much, sir. And we'll take the case under advisement. At this point, we'll come down to Greek Council and take a brief You may be seated. And our final case of the day, number 241186, Wudai Industrial versus Wong. Mr. Bono,
Yes, Your Honor.
good to have you, sir.
Same here, Your Honor. May it please the court, let me start by saying it's a privilege to appear in front of this court again. I always enjoy arguing in front of this court, and I thank the court for the time it's taking to consider this appeal, which, as you might appreciate, is very important to my client. Your Honor, Your Honors, this appeal raises two critical and controlling jurisdictional issues. The first issue is whether the district court had subject matter jurisdiction to enter an extraterritorial injunction enjoining trademark and use conduct in foreign countries. And the second jurisdictional issue is, did the district court have ancillary jurisdiction to entertain a breach of contract claim on a settlement agreement after a final judgment of dismissal with prejudice had been entered in the case? For purposes of those jurisdictional questions, the U.S. Supreme Court has rendered two controlling opinions. The Abitron opinion, which answers the extraterritorial question, and the Kokanen opinion, which answers the ancillary jurisdiction question. And both of those opinions answer the questions I presented on lack of jurisdiction in the negative. Your Honor, if we have time later in the argument, I would also like to address two critical substantive issues, if there's time, one being the complete absence of proof to sustain irreparable injury for an injunction, and the fact that paragraph 6B of the settlement agreement addresses targeted advertising. But for our purposes, I believe the jurisdictional issues answer the questions presented to this court, because the questions are, we have an injunction, and the court has to decide, is it going to sustain or reverse that injunction? And with all due respect to the district judge, the court has, under the new Abitron decision, which came out shortly after this court had issued its prior opinion, so this is a new issue that has arisen in this case. Under the Abitron opinion, the Supreme Court definitively held that the reach of the Lanham Act is domestic only, and that there's no jurisdiction.
Is this injunction enforcing the Lanham Act, or is this injunction enforcing the settlement agreement?
Well, Your Honors, your prior opinion, I believe, answers that question. Your prior opinion decided, as Judge King wrote, that the order at issue, which we're dealing with now, which is virtually verbatim the order that you were dealing with before, was an injunction and not an order of specific performance.
Right,
Because,
we know that. But my question for you was, is this an injunction enforcing the Lanham Act, or is this injunction enforcing a right under the settlement agreement?
yes, you're also held in the prior opinion that the scope of the order at issue, the injunction, was far broader than the terms of the settlement agreement itself. And in fact, that was one of the reasons Judge King
I'm sorry,
cited in
I'm
his...
sure you're getting to an answer, but can you answer my question and then explain it?
I just said it's not, because it is...
I'm sorry, it's not what?
It's not simply an enforcement of a settlement agreement.
So is this this is an injunction enforcing the Lanham Act?
It's an injunction which derives, the court's authority to enter this injunction arises under the Lanham Act, which gave the court subject matter in the jurisdiction in the beginning. We have to understand, this case started where the only subject matter jurisdiction of the district court was the federal Lanham Act. There is no diversity jurisdiction. So its subject matter jurisdiction is provided by the Lanham Act. It is circumscribed by the terms of the Lanham Act as defined by the Supreme Court. It
So I
cannot
guess
exceed...
Is your point that the parties were somehow restricted? The parties could not agree to a global settlement, because they went beyond this dispute and made agreements about things outside the United States.
No, Your Honor, you have
And
this.
now the court has entered an injunction to enforce this agreement that has obligations and responsibilities related to Europe, to other parts of the globe. But because this began under the Lanham Act, the parties were forbidden from agreeing to restrict their behavior in other countries?
Absolutely not, Your Honor. That is not the question that should be answered. You have to distinguish between the parties' ability to enter into a contract, whereby they could decide to restrict activity, and if a party breached that contract, it would be subject in a court that had jurisdiction to an alleged breach of contract claim, and the parties could prove a breach if it was there and seek damages. The question is the remedy of injunction. And the Supreme Court and the 10th Circuit now and the 11th Circuit now following Abitron have all said, and the district courts below those cases have all said, for remedy purposes, an extraterritorial injunction which affects conduct in foreign countries is beyond the jurisdiction of the court in a trademark in use situation.
Because
It
the
does not
jurisdiction
restrict
of
the
the court
parties.
is, the jurisdiction of the court is defined by Congress, right? And when Congress passes the act, it defines the limits of the court's power. It might be different in a case where the limits of the court's power are defined by a contract. And I think that's the question that we need to address.
And the answer to that is the court, there's cases that have been decided by the Fourth Circuit that it's clear that once jurisdiction is defined by the statute as interpreted by the Supreme Court, the parties are without power, so to speak, or without the ability to expand that jurisdiction by contract. So the parties cannot enter into a contract that would expand the jurisdiction of the court to enter the remedy of an extraterritorial injunction. And it's just the same way as general equitable powers of the court. The general equitable powers of the court under this court's precedents that we have cited cannot be used to expand the jurisdiction of the court where that is specified expressly by statute. You can't have a general equitable power that goes beyond the specific designation of the jurisdiction as interpreted by the Supreme Court as to what the statute does. So in answer to Your Honor's question, yes, the contract can give rise to obligations, the subject of which could be subject to a breach of contract claim or a damage claim. If there were any damages, which we respectfully submit there are no damages in this case, they have not submitted any evidence of damages, which is again required under Virginia law. The issue we're talking about here is the remedy of an extraterritorial injunction, not the rights of the parties to enter
An
into a
injunction
contract.
saying comply with your contract, right? That's what
Well,
the injunction says.
that injunction goes beyond what was agreed to in the contract as this court indicated in its prior opinion. That's why it was not a specific performance order.
You're not saying we ruled on the scope of the contract, are you?
No, you simply said that the order was not enforcing the precise terms of the contract, which under Virginia law is what is required for an order of specific performance, and you held that the injunction was beyond the terms of the contract and broader than it, and therefore that was another reason why it was an injunction and not simply an order of specific performance. And that's what Judge King wrote in his majority opinion. So as far as the Abitron decision and the jurisdiction is, it's a question that the extraterritorial injunction is what goes beyond the subject matter of the court's jurisdiction, and why this injunction that was issued must be reversed and vacated. Now, the second jurisdictional question is the question of ancillary jurisdiction, because what we have here now, because Mr. Wong and his company have now argued to avoid the Abitron opinion that, well, we're only really talking about a breach of contract case. Well, the Supreme Court in the Kokanen case said that when you have in order to preserve ancillary jurisdiction, because of course there's no diversity jurisdiction here, and therefore it would be simply a breach of contract claim, the Supreme Court said you must expressly reserve jurisdiction in the final judgment. And in the way you do that is either you must set forth the terms of the settlement in the judgment, in the final judgment, therefore the order of the court becomes in effect what you're enforcing and not just the contract, or you expressly reserve jurisdiction to enforce the settlement in the final judgment. Here, Judge Hilton's opinion, if you read it, seems to overlook the fact that there was a final judgment entered in this case. And the final judgment did not contain the provisions of the settlement agreement.
Now, correct me if I'm wrong, but isn't the chronology, there was a final judgment and then an appeal, and the court reversed and sent it back?
The final judgment was not reversed by this court. The final judgment was not vacated by this court.
So you say there was an appeal of the final judgment. We left the final judgment in place,
And
but somehow reversed and sent it back.
you held that the court had not satisfied Rules 52 and 65 for entry of the injunction order, which the order was entered prior to the final judgment. And the final judgment, there were two, if the court recalls, in the settlement agreement, there were two forms of final judgment, version A and version B. Now, version B had an express reservation of jurisdiction, ancillary jurisdiction, but version A that was entered by the court did not, and it dismissed with prejudice all of the claims of Mr. Wong, the App Police and his company, dismissed all those claims with prejudice, and that judgment is still in place. And therefore, under the Kokanen opinion of the Supreme Court, there's no ancillary jurisdiction now in this court because in the district court, because there's no diversity jurisdiction. And so if the plaintiff wants to argue this is now just a breach of contract claim, there is no jurisdiction in the district court under the Kokanen opinion. It's a very strict ruling. It's a harsh ruling, but it's the Supreme Court's mandate that says, no, this is how you do it. There is no reason to entertain federal jurisdiction of a breach of a settlement agreement unless you put it in the final judgment, and in fact, you're enforcing the court's order.
Just so I understand, so we heard an appeal, we reversed and sent it back to a court without jurisdiction.
The jurisdiction at that time was not an issue because it was a pre-judgment order that was being sent back. The court issued
But there was a pre-judgment order and then a final judgment.
Correct.
That concluded the case. So we
Yes.
have to somehow undo that to get the court back to pre-judgment status so we
No,
can reevaluate
No,
that.
there's no reason to do
So
any
you're
of
saying
that.
when we sent it back, the district court no longer had jurisdiction. We sent it back to a court that no longer had jurisdiction over the case.
No, you ordered us to have the court satisfy the Rule 52 and 65 requirements for findings of fact and conclusions of law. And we followed the court's order, and that's what we did. And that was addressing the original injunction order of the court. So the issue we're raising now, post-judgment lack of ancillary jurisdiction, was not ripe at that time because we were dealing with an injunction which this court said had been issued prior to the judgment and which arose not out of the contract per se, but arose out of a broader ambit of
When did the
ordering.
district court lose jurisdiction?
When did the district court, well, it depends on what claim you're talking about. If it's a claim of whether the contract had been breached, if that's the claim you're addressing, whether there's a breach and whether there should be damages assessed, The court lost jurisdiction on that at the time of the final judgment because it wasn't preserved. The question of whether the injunction was properly entered was the question that was entered beforehand. And the court had jurisdiction at that time to entertain that, to hear that injunction question and to decide whether there was a basis. What happened with regard to that prior order was right after this court issued that order, the Supreme Court issued Abitron and said, injunctions, extraterritorial injunctions, are not available when you're dealing with an injunction that enforces a trademark use in commerce in a foreign country. And that's the new development here. And when we went back to the district court, in addition to submitting findings of facts, we also rose with the court the Abitron opinion and quite frankly said, there's no jurisdiction to enter this injunction. And the district judge completely ignored that opinion, did not cite to it, did not consider it. And when we asked him on a follow-up motion that he didn't address it, he said, take it up with the appeals court. And I'm not considering it. So I see my time is up.
Did he say that in writing, or did he say that in?
He said that in an order denying stay. He said, take it up with the appellate court. That's what he said. And I'll leave it up to you to decide what he meant by that. But that's what he did. The bottom line is, we raised that issue. It was a new issue. First came out after this court's prior appeal from the Supreme Court, and he did not address it. And we feel it is absolutely controlling in this case. I see my time is up. Thank you very much.
Thank you. Mr. Riley?
Yes, Your Honor, thank you. May it please the court, Craig Riley here for Mr. Wong and his company. As this court previously found, the parties' dispute arises under a concurrent use agreement. That is, the parties had agreed that they could continue to use their own marks subject to specific restrictions and negative covenants that are stated in the settlement agreement, and this governed the worldwide promotion of their products. So what we have here is a case in which we are enforcing rights that arise under the concurrent use agreement, which are governed by Virginia law, and we are not bringing trademark infringement cases that arise under the Lanham Act. And I'll address the ancillary jurisdiction question first. I think Booty misreads the settlement agreement and the stay order, as well as versions A and B of the final order. The settlement agreement in paragraph 10, this is found at the joint appendix at page 945, was filed with the court, and the parties agreed to ask the court to retain jurisdiction over the entire settlement agreement. There are no conditions, no sunset event, no expiration date, nor any limited duration of the retained jurisdiction. The stay order in the first paragraph says, it ordered that the court will retain jurisdiction to enforce the settlement agreement, and then states in a second separate paragraph, and it is further ordered that this matter is stayed pending entry of the final judgment presented to the court pursuant to the settlement agreement. Essentially, the parties set up a two-step process for entering the final dismissal order. Version A, which was the one that was entered before this case was heard on appeal here, enters judgment for Woody on its complaint to reverse the TTAB ruling and dismisses my client's counterclaims. But that's all it did. It does not address, let alone terminate, the other provision in the stay order, which retains ancillary jurisdiction. Therefore, there is ancillary jurisdiction that survives the entry of the final judgment under two independent theories. First, even if the entry of final judgment somehow affected this court's jurisdiction or the district court's jurisdiction, this enforcement proceeding began during the stay period, was appealed, then returned to the district court for further findings and conclusions on that enforcement motion, and then appealed again. Thus, this appeal is simply a continuation of the enforcement proceeding that began during the stay period when ancillary jurisdiction unquestionably existed. And so ancillary jurisdiction over this continuing enforcement proceeding has not been displaced by the final judgment. Second, interlocutory orders, particularly ones structured as the stay agreement was, are not extinguished by the entry of final judgment, but they merge into it. We cited a case to the court on this point at page 13 of our brief, footnote 4. That is, version A and B were meant to be part and parcel with the stay order in order to effect the final disposition of the action. So there was a two-step final order here. The stay order first, retaining jurisdiction to enforce the settlement agreement, and then the version A or B that would be presented by the parties later. Mr. Bono points to version B and having certain savings clause in it about retaining jurisdiction that may be surplusage, but in any event, version B would have been a very different final order to be entered at that point. It assumed a breach by Woody of the payment terms, which is what the court was staying the staying the case for. So it enters a judgment, that second version, which didn't go into effect, enters judgment against Woody on our counterclaims, affirms the TTAB ruling, which would have excluded Woody from the United States market altogether, and enters a money judgment, net of any payments made to us. So it's granting actual affirmative relief to Wong in the second version. Again, that was not entered. The savings clause, and this is important language, says, in addition to the relief that's actually granted in that version, all other terms of the settlement agreement remain in effect, and the court retains jurisdiction to enforce said remaining terms and conditions. This was simply to clarify that despite the affirmative awards of relief to my client, excluding them from the U.S. market, granting us a money judgment, that did not become, that not all the other relief did not merge into that. Abitron, I would like to address next if the court doesn't have any further questions about that first point. This argument made by Woody, I think, conflates statutory construction, subject matter jurisdiction, personal jurisdiction, and the court's equitable power. Abitron simply analyzes whether the modern test for the presumption against extraterritoriality, application of federal statutes applies to the claims asserted under the Lanham Act. But the claims, as this court has held, arise under the concurrent use agreement. That's a contract, and that governs the parties' use of their marks worldwide, and the agreement is governed by Virginia law. They've even argued Virginia law to the court, so do we. Nobody's argued for any Lanham Act interpretations or applications. Nobody is seeking Lanham Act remedies here. We are seeking remedies under the contract. We cited the case of the AFCO decision, a district court decision, but it was the only one I could find where this distinction was raised, and in that case they said that the extraterritorial limitations on the application of federal statutes, in that case in particular, the Lanham Act, do not apply when, as that case and in this case, what we are arguing about is the parties' rights under a concurrent use agreement, and in that case, the court took action with respect to the defendant's use of marks in Saudi Arabia. So again, it was an extraterritorial act of relief that was sought. So the basis for jurisdiction for the district court to have entered an extraterritorial injunction are straightforward. It had ancillary jurisdiction as its subject matter jurisdiction, and that applies regardless of the grounds for the original jurisdiction and applies regardless of the diversity of the parties. Throughout these enforcement proceedings, the district court has noted, and I think the court in the dissenting opinion, Your Honor, noted this, the district court was exercising ancillary jurisdiction. So throughout these enforcement proceedings, the district court has exercised and noted it's exercising ancillary jurisdiction to enforce the settlement agreement. What you have to have in order to enter an extraterritorial injunction is personal jurisdiction over the defendant. To that, Woody consented, and they don't dispute it. This is found in the joint appendix at page 945, In the settlement agreement, paragraph 10, they consent to jurisdiction that's binding. The court then, as we analyzed in our brief, has equitable power. If the court has personal jurisdiction over the defendant, it has the power to enjoin the defendant, whether the defendant is within or without the United States, or to order the defendant to take action, whether that is within or without the United States. Therefore, the district court, having retained ancillary jurisdiction, having had personal jurisdiction over Woody, has the equitable power to enter an injunction that has extraterritorial reach. Woody has also complained that the district court didn't amply analyze the eBay factors. Judge Hilton's opinion is concise and amply states all of the grounds, and he considered every one of the eBay factors. First, the breach of this sort of agreement causes inherent injury and irreparable harm to the plaintiff. This is found in the Dewberry case, the district court decision by Judge O'Grady, which this court later affirmed, the Helix case, and the Long John Silver case, which we cited. The breach of a contract not to use a mark causes, in quotes, injury to the goodwill and an inherent injury to the goodwill and reputation of the plaintiff. You are not required to prove damages because we're not seeking damages. And under Virginia law, he said we didn't show damages which were required by Virginia law. The Virginia case law says injury or damage. And all the cases I've found where you've had equitable relief as the relief sought by the plaintiff, all you need to show is injury. Furthermore, under Virginia law, this is the Worry versus Bose case, which this court cited in the Dewberry opinion. There is no need to show actual damages. Rather, you only need to show that the breach, quote, may result in injury, close quote. So the Dewberry case, citing Worry versus Bose, said, and I'm quoting from the Fourth Circuit's opinion here, reputational harm is sufficient to demonstrate irreparable injury flowing from the breach of a settlement agreement restricting the breaching party's use of a trademark. This is also echoed in the cases we've cited, the Blue Cross, Helix, and Long John Silver cases, and the Dewberry District Court opinion, that a breach of this sort of a contract causes reputational harm, it's inherent, and it's irreparable harm for which damages are inadequate. With respect to the public interest factor under eBay, again, this was analyzed in the Dewberry opinion, the Helix and Long John Silver cases. It says you enforce contracts regarding the restriction of use of marks to prevent consumer confusion and to encourage the public's understanding that contract rights will be enforced. Those are the public interests served by the injunction here. They argue about the balance of hardships. Again, they ignore that there's inherent injury to my client. We basically set up fences. You stay on your side of the fence, we'll stay on our side of the fence. We've done that. They have not. And as soon as they cross over the fence, they say, well, it doesn't harm you. You have plenty of space in your lot. I'll just take some of it. No, that's why we built the fences in the first place.
They made
yes.
I think they made an unclean hands argument that it's kind of that variety. Well, they didn't comply with other parts. That's an equitable claim? Is that part of this equitable balancing of the harms in the eBay factors that the court considered the harm and the damage done by each side?
It can be, yes. But I think what we have here is this enrichment claim was extensively briefed and vigorously argued below by Woody, and it's unmistakable that Judge Hilton rejected it. Now, I'll acknowledge he doesn't say that in so many words in his decision.
But in his balance of the harms, he found Wong, that the balance favored Wong. Is that an equitable balance?
That's correct. That's correct. But just on that point, I think the evidence that was presented was incompetent. It was simply waved around by counsel at the 2022 hearing before Judge Hilton the first time he heard this and entered the specific performance enforcement order. And it was not verified by a declaration at that time. It's not, none of that has And they failed to provide any notice in advance of asserting that defense, which is, of course, a contract prerequisite to asserting any sort of a claim of a breach for any sort of relief. So we've analyzed this in our brief that they really didn't meet any of the criteria for the admissibility of this evidence or the legal impact of it, but it's certainly in the balance of equities. Judge Hilton did not credit it as a reason to not enter the injunction. And then one of the other arguments that they made repeatedly, and this was more in their first appeal and in the first district court hearing on this, was that this was somehow causes no harm to my client, but somehow grievously damages them. This is what they agreed to do. And now they're coming in and saying, well, it was more expensive than we thought it was going to be, and therefore it's onerous. Well, that's not the way it works. And it's not even right under the, if you look at the agreement. The agreement, we anticipated that this was going to come up, and we agreed to these specific limitations. We said it's only limited to 3 classes of products. It is only limited to the ECO, and we already pre-approved a dozen other marks that they could use freely in Europe. These are called the European marks. And these are found, identified at page 955 of the joint appendix. There's no question that we anticipated that some of these restrictions would cause some problems, but here are the ways to solve it. Not only that, but they acknowledged in 2022 that they also had the ability on social media to use geo-blocking as another way to ameliorate the effects of this. For all those reasons, this is not an onerous provision, and the balance of hardships does not shift to them. With respect to, they said, oh, it'll cause us damages. They were the ones asserting money damages. They never specified even an amount, only just made these unquantified arguments, which is not sufficient under the law. If I could turn to the substantive arguments about the meaning of paragraph 6B, these restrictions are aimed at consumer keyword searching. Their twin aims of paragraph 6B are to limit Woody's keyword purchases from search engines and shopping sites, and then second, to limit Woody's content posted on social media platforms that may be accessed and viewed in the ECO. These twin aims are stated in different prohibitory language. The first clause says, Woody will not buy from search engines and shopping sites. That limits the purchase of meta tags, keywords to trigger paid search results. The second clause states, Woody will not use GT Racing on Facebook and other social media platforms. That clearly limits content posted on Woody's social media. Each time the parties in this contract are limiting content, they use the prohibitory language, will not use. This is found in paragraphs 4, paragraphs 5, paragraph 6A, and paragraph 6B. The first clause, again, limits Woody's right to generate paid search results by purchasing GT Racing as a keyword meta tag, such as a Google AdWord, from search engines or shopping sites accessible in the ECO. The second clause limits their ability to generate natural search results by using GT Racing as content on its social media platforms that are accessible in the ECO. Importantly, they argue now that, oh, those are audience targeting limitations. No, these are brand names of theirs that we're limiting, and none of the restricted terms deal with audience targeting or audience demographics, age, location, and so on like that, which is what those other tools that they now are proffering, by the way, and we submit in violation of the mandate rule, they submitted 400 pages of new declarations, new exhibits, new arguments of counsel, new contentions and new theories of their defense, all when we got back in front of Judge Hilton the second time after this court remanded it. The paragraph 6 limitations are aimed solely at restricting results generated by consumer keyword searches. Now, their argument that it applies to, oh, no, what it really applies to is these hidden meta tags is defeated by their own client's declaration in 2022. In 2022, Mr. Wu Peng says that paragraph 6B constitutes, quote, social media restrictions that prevent Woody from using its GT Racing mark or the words GT Racing or GT Space Racing in connection with certain goods in the ECO. They also admitted that these were accessible and could be viewed in the ECO. In paragraph 14, that was paragraph 9, found at Joint Appendix page 195. Joint Appendix page 196, paragraphs 14 and 15, Woody's global media is available and accessible, using the same words we do to describe how you use the internet. Woody's global social media is available and accessible on the internet. It is inevitable that individuals in ECO countries could be able to access these applications and view Woody's promotions and advertisements. He clearly, Mr. Wu Peng clearly understands that 6B was limiting content as well as meta tags here, because he's saying that it can be viewed. You view content, the meta tags, as this court has analyzed in prior opinions, is invisible to the viewer, the user accessing the web page. So it's talking about content. They also admit in paragraph 15 and 16 that there's, I see I'm running out of time.
I've got a question I want to ask you
Yes, sir. Why don't I get right to that then?
about costs. You made a motion for costs? You made a motion for costs, and they were awarded by,
With respect to the motion below, we made an application to the court for fees.
for fees.
Correct.
And the judge, I think his opinion says you're awarded fees, or costs. I thought it would say costs. And they say that you made a motion and the agreement required you to file a lawsuit.
Yes, Your Honor, and that is the argument that they made. I am following your question. And we simply cite, it's a very broadly worded provision. It uses the word suit. You have to file a
The
suit.
difference between motion and a suit, but the cost, and they were awarded, but there's no number anywhere.
This is a typical practice with the Eastern District Alexandria judges and Judge Hilton in
So it's not
particular.
final as to that.
I would make a filing, I made a filing after that, and he just didn't, it's still sitting in his chambers, I'm sure.
No, but the award was made. He ruled in your favor. Judge
Yes.
Hilton ruled in your favor.
Right.
And I was going to ask you, what's the number?
Oh, I think it was like $15,000. I don't have that number off the top of my head. But it was not included in his order because, again, he directed me to make an application, which I did, and then he,
But they say, and I got, maybe it's in the reply brief, that you didn't file a lawsuit and the agreement requires a suit.
yes.
All you did was make a motion.
That's correct.
Are you agree with them on that point or not?
I agree with, the word used by the parties was that if the prevailing party files a suit, and we pointed out, Black's Law Dictionary, that a suit is actually a generic word for any sort of an application to the court for a remedy.
So you saying that in the context that there's a motion, there's a suit. All right,
Yes,
that's fine.
and that's as
all you
as
got
far as we
is a
take
motion.
it, Your Honor.
You just got a motion.
All right. But-
Counsel, I have a
Yes, Your
question. What you would respond to a little more fulsome is in the reply brief, page 9. It says that an interpretation of the paragraph 6B is a blanket social media restriction. If we do that interpretation that broad as the district court did, it would prohibit Woody from promoting his products elsewhere in the world outside of the ECO, just because the same social media posts also happen to be accessible in the EOC via internet. I mean, they paid $4.5 million for something. It basically, that interpretation would be the benefit of the bargain is just sort of evaporates.
No, and we addressed this in our brief to an extent, but I will address that directly. No, the $4.5 million was part of the bundle of rights and restrictions that the parties exchanged.
Right.
We had our counterclaim for trademark infringement damages was had a number of $10 million or disgorgement of their profits. So that was one thing that they bought with the $4.5 million. Further, they bought the right to sell products in the United States, which was
Right.
barred by the TTAB ruling, which we agreed we would walk away from, and we assigned certain rights to them in the EU and the UK, which both have separate trademark regimes. So they got a lot more than just
But respond to the
this.
part that said, but it's that blanket type interpretation would also impact the markets beyond the EOC carve-out. In other words, it's pretty broad, isn't it?
The restrictions
Right.
on the ECO, again, the parties both had in mind, and in fact, this is in Woody's 2022 declaration as well, they understand that there is geo-blocking that allows them to carve out the ECO. If they want to throw out their internet social media marketing throughout the world, they can use geo-blocking to block out my client's protected territory. Or they can market all their other products through global social media, including anything outside the restricted three classes of goods. So they have other rights that they could use, or they could switch over and in their global social media use any of the 12 pre-approved trademark and branding rights that we gave them. So we're not restricting them from implementing a global social media marketing promotion, but they agreed to certain restrictions. We agreed to ameliorate those restrictions by limiting it to the ECO, three classes of products, and to have pre-approved other trade names and brand names they could use for their products there. So this is not a situation where they are forced to shutter as they've sort of come in with their hair on fire exclaiming, oh, we have to shutter all our social media platforms. That's not the case at all. We anticipated this, and they also anticipated using geo-blocking. Not required by the agreement, but certainly available to them, and they know it. And this is something that they have used on certain social media platforms, but not on others. This is in Mr. Wu Peng's 2022 declaration. With my time having expired, I would ask the court to affirm Judge Hilton's ruling here and the injunction, and I thank the court for its time.
Thank you, Mr. Riley. Mr. Bono?
Thank you, Your Honor. Nothing counsel stated undermines or takes away from the fact that under Abitron, the injunction is beyond the subject matter of the district court. Virginia law cannot expand a federal court's limited jurisdiction beyond what the statute provides as interpreted by the Supreme Court. He stood up here and said the court can do that under Virginia law. No, it can't. He said the court can do this under its general equitable powers. No, it can't. He said that the courts can do it because of the party's contract terms. No, it can't. None of those can expand the court's subject matter jurisdiction. Federal courts are, as you know, are courts of limited jurisdiction. They get the jurisdiction from the Constitution or federal statutes as interpreted by the Supreme Court, period. It is a strict application. I would like to note, he cites to the stay order and avoids the fact that the judgment did not preserve jurisdiction. The Supreme Court in the Coconut opinion, whether you agree with it or not, it is the law of the land, and it says you must expressly reserve jurisdiction over a settlement agreement in the final order of dismissal or judgment, or have an independent basis for that contract claim. And here we have no diversity of citizenship jurisdiction, and there's no jurisdiction. He quotes the court's interim stay order, which was right after the settlement agreement was entered, but prior to the judgment, which was over a year later. The stay order does not provide you with any reservation of jurisdiction once the judgment is entered. The Supreme Court says that in Kokanen. You cannot do that. And the order itself, the stay order itself says it's in effect pending entry of the final judgment. So on its face, it expires, and the reservation of jurisdiction expires upon entry of the final judgment. He ignores the fact that, as I said earlier, the final judgment excluded, the parties purposely took out the reservation of ancillary jurisdiction in the version of the judgment that was entered. It was in the other version of the judgment. Nothing could be clearer, I submit to this court, than the purposeful agreement of the parties to remove ancillary jurisdiction. In fact, Kokanen says the only way you keep jurisdiction if the parties agree to put it in the dismissal order. Here it was just the opposite. The parties expressly took it out, having written it in the other version. So nothing could be clearer. Now, I would like to comment briefly on irreparable injury that I alluded to before. There is no, and he rests his entire claim on that element of the eBay factor on presumption of irreparable injury. You don't just get presumption of irreparable injury in a vacuum. You have to put in proof, some proof of harm to reputation, to goodwill, to customer confusion, to loss of sales, something. You have to have a basis, a predicate for harm. You don't just say, oh, I can rest on a presumption of irreparable injury. The only evidence that he rests on of irreparable injury is one sentence in a declaration by Mr. Wong that was filed 32 months ago, in which he says, oh, the viewing of these social media posts causes, affects my online advertising. That's what he says. First of all, that's insufficient in itself, even if we were here on April 1, 2022, because there's no facts to support it. So it's a conclusory statement. It doesn't support the fact. The fact. You have to show fact of harm to reputation before you get the presumption. And here we sit 32 months later. There is no evidence in this record. No evidence. For 32 months, they had the opportunity to put it in front of Judge Hilton. They decided not to. No evidence of harm. No evidence of injury, no evidence of damages, no evidence of reputation, customer confusion, lost sales, lost revenues, lost customers, customer inquiries, nothing. And they want an injunction because they say, oh, we have a presumption of irreparable harm. They haven't sustained their burden.
Is it relevant that the T-tab earlier found a likelihood of confusion because of the similarity of the marks?
That was, yes, Your Honor, that was at that time under that standard. But here we sit with a fuller record, and now we're years later, and the question is, where is the harm to reputation? They said the marks could be confusing, but we don't have any evidence of harm to reputation or harm to goodwill. The essence of irreparable harm, the presumption is, their reputation has been harmed, their goodwill has been harmed, and it's difficult to prove damages. That's why you have the presumption, but you have to have the harm. Here, significantly, this order, the injunction, restricts conduct in 53 countries. 53 countries. And there's no evidence, except for 2 instances, and I'll get to those, but there's no evidence for 51 countries of any use of Wong's trademarks or economic activity in 51 of those countries. And as this court has held in the case we cited in our brief, you must have use in commerce in order to assert irreparable harm to your reputation and goodwill when you have a trademark dispute. There's no evidence. You do not know whether in Latvia he even uses this mark or he even sells his products, or Estonia. You don't know anything, but he says, I want an injunction. And there's nothing in this record. He had to put in, the burden is on Wong to establish those facts. He put in nothing. And as far as Scotland, his declaration from, again, 32 months ago, Wong says, I went online and I managed to get some access to some videos or postings. Well, he's a computer wizard who knows what he did in order to draw that out of the internet.
There are red lights on there.
I'm sorry. All right, I will stop my argument unless the court wants me to raise any other issue.
Thank you very much.
All right, thank you, Your Honors.
Good to have you all here.
Thank you.
We'll take the matter under advisement, and we will